We're still looking at issues to do with contracts. This time we're looking at unjust contracts. Unjust, so not just contracts, right? And what the Board of Studies and blah, blah, blah requires you to do is examine the nature, function, and regulation of contracts. And we know this, right? But it gets a little bit confusing the way that they've structured the syllabus because the law doesn't really reflect the way the syllabus is written anymore. So it can cause a little bit of confusion. Now, the first question that you might ask is, why is the contract unjust? What is it about the contract that is unjust? Is it just the terms? So the contract itself, are there terms that are not just, that are not fair? But why would someone sign a contract that has unjust terms? Why would you sign that? And then we start looking at some of the problems, like maybe they were taken advantage of, right? And that's called unconscionable conduct. And that itself, the conduct that led up to the contract, that's not the contract itself. So it's not saying that that's an unjust contract, but the sales tactic used in order to get the person to sign the contract, in which case that's also like a marketing issue as well. And that's covered by a different part of the syllabus, right? So it kind of blurs the lines here. Now, why is this even an issue? The reason that this is an issue is that it used to be a lot clearer which issues had to do with contract law and which ones were about sales and marketing. Now, when the syllabus was released in 2009, when it started in 2009, 10, 11, it was much clearer. These are the contract issues, and there are a set of laws about contracts, and we looked at that, and then we looked at marketing, which is kind of a separate thing. But the ACL, the Australian Consumer Law, when it was passed in 2010 and started at the start of 2011, ended up blurring the lines there because the ACL has these things, these general bans, which can be applied to contracts. They can really be applied to any business behavior that has to do with misleading and deceptive conduct. So, yeah, you can have misleading and deceptive conduct that leads to a contract, of course. Another ban is about unconscionable conduct. And of course, people, taking advantage of other people and getting them to sign a contract that, is really unfair, that is really unjust. That's unconscionable. So say it's a pensioner or someone like that. It's unconscionable. It's wrong. It's a real horrible thing to do. And the third general ban is about unfair contract terms. So the actual terms themselves. So we've already seen an example of these blurred lines. If you remember the HP case, the Hewlett-Packard case, yes, it was a contract issue. They did have illegal terms in the agreement and leading up to the agreement, as what they were told. But the ACCC didn't really focus on that. They focused on the misleading and deceptive conduct, that first general ban, as a way to nail HP to the wall because they just had to prove that there was, conduct that could end up misleading or deceiving people. And that was much easier than to say, okay, well, let's just look at the contract here. It was, let's look at all of the behavior, including the contract and everything before it and all that and everything after it. So we're going to look at it as a whole and we're going to use that general ban. So, for argument's sake, we're just going to pick categories here, right? So we're going to split all of these things, these issues that we're going to look at, into like unjust contracts or whether they're advertising, marketing, selling issues. Now, in the end, it doesn't really matter for you because it's not, you're not going to be asked, which, syllabus dot point comes under here. You're not going to be asked to categorize things. You're just going to be asked to write an essay, right? And that essay, you could talk about these things, I guess, in either one. You could say, well, there is, advertising and marketing and sales tactics in general that might be also unconscionable and lead to an unjust contract, right? So you can blur the lines yourself in order to make the question suit you. Yeah. So we're just gonna, just for argument's sake, we're just gonna pick categories. So let's go. We've got unjust contracts and marketing and advertising. So under unjust contracts, so in this one here, in this video here, we're going to be looking at these things. So we're going to look at unfair terms. We're going to look at contracts with minors. We're going to look at things like duress or coercion, as well as undue influence. And we're going to look at unconscionable conduct here. Even though I guess you could do it in the marketing and advertising because, it's like things like door-to-door sales and telemarketing and some of the tactics that they use in order to get someone to sign an unjust contract. So yeah, you could do it in here. It doesn't really matter. So the regulation of marketing and advertising, we're going to look at, this is when we're going to look at the misleading or deceptive conduct or misleading or deceptive claims, representations, statements. We're also going to look at things like pricing, so displaying prices, so component pricing and dual pricing, and you'll get to see what those are. And then we're going to look at social media and online reviews, and we're going to look at how those are, affecting people's decisions whether to buy or not. So, just focusing on this left-hand side for this video, most of these things have a mix between common law and statutory protection. So you can see under the yellow dot point, it says unjust contracts, and it says common law, and then it says statutory protection. So yes, common law protects us. Yes, statute law protects us. But common law is a lot less common now. If you were teaching this, 30 or 40 years ago, common law would play a very strong part, the most part in dealing with unjust contracts. So we still do have some cases, and there are some case names, and it's helpful to have some case names because it's nice to mix it up, like writing an essay. And if you just have law, like statute laws all the way through, you don't have any cases. The marker might be left thinking, oh, what cases aren't good enough for you? Well, you're not going to put any cases in. So some teachers really love cases. They think cases are, at the heart of it, despite the fact that, in this area, we have very strong statutory protection under the ACL. So let's start with that first one, with the unfair terms. Section 23 just bans unfair contract terms. Now, it's a little bit strange to see that phrase unfair terms, right? Because remember, we saw that stupid contracts are still contracts. So if you sign it and you don't read it, then it's your fault, right? So how can we have an issue with unfair terms if you are bound by things that you sign, whether you read them or not? Because, I'm sure that there are things that, you've signed and you've agreed to when you're, like installing software or something like that. Maybe there are unfair terms in there, but too bad. Like, you should have read it. Yeah. So there is this balance between to what extent can you legally trick people, and can you not? Do you get stopped from having unfair terms? So the specific thing that we're going to look at here is not any contract, a special type of contract, the one that we looked at a little bit, called the standard form contract. That has a very specific meaning under the ACL. So usually, like if you can buy a phone, go into a phone contract or something like that, they will have a standard form contract. It's already been written for you. There's no negotiation. You don't sit there going, actually, no, I'd prefer to have this. You just go, okay, well, where do I sign? Because you've already printed it out. You're not going to, cut and paste things, and maybe it's just like a PDF, like you can't do anything. So they have these standard form contracts so that the contract is the same for everyone who is a party to it. Everyone who's going to sign is going to have it. Now, these standard form contracts, we know, can take advantage of thousands of consumers all at the same time. So the lawyers work very hard to make sure that they can keep that. So if we go back to that, see at the top there it says Section 23 of the ACL. This is Section 23 of the ACL. It says unfair terms of consumer contracts. A term of a consumer contract is void if A, the term is unfair and the contract is a standard form contract. So we're not looking at other types of contracts. We're looking at standard form contracts here, right? So that's what the unfair terms section deals with. So how do we know if a term is unfair? We know, we'll be able to tell if it's a standard form contract because, it usually has like the company logo on the top and they have lots and lots of copies of it and it's all the same and different customers have the same contract. Pretty easy to prove that. But how do you prove that a term is unfair? What does unfair mean? Well, under the ACL, it's unfair if it causes a significant imbalance between the rights and obligations of the business and consumer. So usually it'll be the consumer has to do everything and the business is responsible for nothing. That is a significant imbalance. But that by itself doesn't make it unfair because there are plenty of times that there is a significant imbalance between the rights and obligations of the business and the consumer. That's the nature of business, right? That's what businesses do. They want that imbalance there. So there are additional things that need to be there. So one thing is that it is not reasonably necessary to protect the business. So if you have a term like an exclusion clause or something that you really don't need to have there is really no reason why the business would need that. It's not reasonably necessary to protect the business by having that term in there. And you also need to be able to prove that it would cause the consumer, and the quote there is detriment, so financial detriment or non-financial detriment, if it were enforced. So those are the criteria for an unfair term. And notice that I've got in big capital letters after each one, and, because you've got 1, 2, and 3. It's got to have all three. Maybe it does cause a significant imbalance, and it is reasonably necessary, but it doesn't really cause too much of a burden for the consumer. They just don't like the term. Or if it doesn't cause a detriment, like some sort of detriment, then it's not unfair because no one's really getting hurt there. And there's also one additional little thing, which is whether the terms of the contract are transparent. Now, transparent means see-through, but we don't really mean like transparent, like see-through, right? A see-through contract, yeah? So here, sign this. Oh, this is just blanket. We don't want it to be completely see-through. We want it to be easy to see what the terms mean. So you'll see contracts now are very different to what they were even 5 or 10 years ago, in that they're actually going out of their way to try and put it in plain English, because they know that under the ACL there will be a question that if it is not in plain English, if some contracts, some businesses have had these contracts where it's got a whole bunch of double negatives, like the consumer is not able to not do this, this thing, right? And that's not really transparent. That's confusing. Sometimes the terms will interfere with one another and can't really work together, and then it's really not fair. It's an unfair term because it's contradicting another part of the contract. Yeah. So we need to make sure it's written in plain English and it's very clear what the obligations are. But even though we do have this definition of unfair, and it still seems like a pretty big thing, wouldn't you think that there are tons of unfair contract terms in these standard form contracts? And if your feeling is, yeah, well, all right, yeah, there's the law there, but heaps of businesses are ripping off their customers. You're right, yeah, your feeling is correct. So, and the ACCC had the same feeling, had that same feeling. So the ACCC did this review, in 2013. And leading up to 2013, they just picked the major industries where they get the most complaints from about the standard form contracts. So phone contracts, they get lots of complaints about their contracts. Fitness, like gym contracts, like signing up to a gym, they get lots of complaints about there. Airline contracts are confusing, and so many of the terms are just not fair. They require extraordinary things of the consumer, while nothing is required of the airline. And vehicle rental industries. These industries are the ones that the ACCC identified as being the big problem ones, right? So they did this review, and during the review, ended up having a report: unfair contract terms, industry review outcomes. Now, during the review, they kind of called a ceasefire. They said, right, we're doing this review. You can send us, say you're a gym, say you're a 24-hour gym, and you're thinking, ooh, I don't know whether my standard form contract is going to be unfair or not. They said, well, send us your standard form contract, and we promise we won't take you to court about it. We're not going to take you to court about this. As long as if we find something that you change it, you're going to be fine. So in the airline industry, they like all the major airlines, most of the major airlines, they sent their standard form contracts to the ACCC, realizing that this is a good opportunity, that they just had to work towards compliance rather than the contract already had to be perfect. So they sent them to the ACCC. The ACCC said things, oh, look, these types of terms are unfair. These terms in your contract are unfair. And that's it. They just sent them back. They didn't sue them. They didn't take them to court. Didn't do anything. They just said, right, well, these are the terms we identified. And in the airline industry, 79% of the ones at the ACCC said, ooh, you better not, that's an unfair contract term. 79% of the, what they called problematic terms, were changed. So when the ACCC looked at the contracts, they found problems, they sent it back to the airlines, and 4 out of 5 of the bad, the unfair terms that they could find, weren't necessarily proven to be unfair, but looked unfair. The airline industry changed them, right? So the airline industry was quite compliant in this, and the review overall was great because it gave businesses like them a good chance to do the right thing. Right? They make these standard form contracts, And until someone actually takes them to court, they're not really certain that they are bulletproof, that they are binding, that they are perfectly legal. So it gave the businesses a good chance to comply, and it reassured them that yes, your contract is okay. Now, for us, for and you, for legal studies students, it's really good that they did this review because they gave a summary of the types of terms that are going to be unfair. So when we look at unfair terms, this review found all these real ones, and then they kind of categorized them. They said, well, when we looked at these contracts, these standard form contracts from the telecommunications, the fitness, airline, vehicle rental industries, these are the types of terms that we think are unfair. So these are the types of terms. So the first type of term is any term that allows a business to change the contract without the consent of the other person. Because that's not fair, right? If it says like right at the top, this contract can be changed at any time for any reason by one side, but not the other, that's going to be unfair. Any term that unfairly restricts the customer's right to cancel the contract. So things like some of the gym contracts had very very long minimum contract periods, and then if you wanted to get out, there were big exit fees, despite the fact that it really doesn't cost anything for them. It doesn't cost anything for them to for you to cancel the contract, right? It's not like they have to pay someone for something. It's just that they miss out on sales. So they would charge these massive exit fees to scare you from getting out of your contract. The third type of contract that was seen to be unfair was that ones that allow the business to terminate the contract, right? Even when it says the customer can get a refund, really we want to make sure that when a business signs a contract, that they are just as bound by it as their customers. It's only fair that they're just as bound by it as their customers. So just allowing the business to just unilaterally, just one-sidedly cancel the contract for no good reason, those types of terms were seen as unfair. And the fourth type were any terms that limit a consumer's rights under those consumer guarantees. Those standards implied by statute, those consumer guarantees, acceptable quality, etc., etc. Remember the HP case? They had terms, and their people on the phones, in India or where they were, they had gone against the consumer guarantees. They said, well, you don't really have these rights. You don't have a right to a refund unless we fix it, multiple times, and that's not true. So you can't, contract your way out of the statutory consumer guarantees. So once they did this review, they said, all right, now that we've done this review, we're going to go after some businesses because not all businesses really went with this. No, they didn't take up the amnesty, the ceasefire, and say, okay, well, have a look at our contract. Some businesses just wanted to keep going. So take for example, ByteCard. ByteCard was an ISP, and the ACCC took them to the federal court. And this is the first case where the ACCC took a business just using the unfair contract terms section. Now, the law had been in place for 2 years by this point, and this was the first time. So this is a big deal. The ACCC was pretty excited. They're like, yay! It's a case that's not, just about advertising, which a lot of the other cases had been. It's not about, false and misleading, representations or whatever. It's about unfair contract terms. Yes. All right. Now we get to see whether we have that, power, whether the federal court is going to back consumers or whether they're going to pussy out and just back the businesses. So the background of the case was that ByteCard, they had a standard form contract for its customers, right? And the contract included these awful terms. So things like, they said that we can change our prices without letting the customer choose to cancel the contract or renegotiate it. So when you do that, and phone companies have been guilty of the same thing, you're saying, okay, well, we are going to change our prices. Say we are going to charge $10 extra a month. When they do that, they should be saying, right, we are going to charge $10 extra a month. We understand that that's not what you signed, so you have a chance to get out of this contract now. That's what they were supposed to say. But what they said was, we have a right to change the contract terms whenever we want, and we don't need you to be able to choose. It also made sure that ByteCard wasn't responsible for any losses to the customer. Um, it's really typical for businesses to say, we accept no responsibility for any loss while you're using our services. But they put that in. Sometimes they specifically mention, unless under law we are responsible. So their one said that even if it was by the misconduct of ByteCard, even if someone at ByteCard had done the wrong thing, if they had taken your details and sold them to someone, and they used it for some nasty purpose, and you ended up losing all your stuff. ByteCard said, well, that's not our fault either. We are not going to be responsible, even for willful negligence, even if we are hopeless, even if we put we accidentally upload our client's credit card list to the internet, and people take it down, they lose money. Even then, we're still not responsible, right? One of our people, we go and we burn down your house, we're still not responsible. So they basically said we are never responsible for anything, even if we did the wrong thing, we are still not responsible. It also made sure that ByteCard was able to instantly end the contract whenever they wanted, with no notice, nothing, right? But on the consumer side, if they wanted to end the contract, they needed to give written notice, and they needed to do it before a certain date in the month. Plus, they had to pay out the rest of the contract from their side. So, having ByteCard being able to do that, does that fit in with the criteria I gave you for unfair contract terms? Well, the federal court decided yes, it does. It's under sections 23 and 24 of the Australian Consumer Law. ByteCard's contract, yes, it did cause a significant imbalance. Yes, it did. Yes, it wasn't reasonably necessary to protect the business. It wasn't reasonably necessary to say that we are responsible for nothing ever. That's not necessary to protect the business. So yes, there was an imbalance. No, it was not reasonably necessary. And yes, it would cause the consumer detriment if it were enforced. If you enforce that against them, then every time a consumer wanted to cancel their contract or whatever, it would cause them a huge financial detriment. Right? So they proved the case here. Now the ACCC had already warned telecommunications businesses, especially, not to have those terms that allow change to contract terms without consent, not to restrict the customer's right to cancel the contract. So things like exit fees, we've gotten to the point now that in some industries, so for like home loans, they're banning exit fees. Or they have banned exit fees, so that you can't just charge a customer because they don't want to be your customer anymore, right? And any term that allows a business to just terminate the contract, if it says we can end the contract at any time and you can end the contract at any time, that is not an unfair term, right? It doesn't have that significant imbalance aspect. So if we go back to those things, if you remember those things, there's significant imbalance. No, it's not reasonably necessary. Yes, it would cause detriment. Yeah, it does. Now down the bottom there, remember I said there's an extra little thing about whether the contract terms are transparent, like are they written in plain English? Well, that's what we're going to look at here. There was a case, Kaczarski and Air Pacific. So Air Pacific, Fiji's international airline, probably flies to Australia. So this case was a New South Wales case, right? So remember, we still, same thing applies. Australian consumer law still applies. So this went to the old place, which was the CTTT. So Consumer Trade and Tenancy Tribunal. Now we just have this one, super tribunal called NCAT, and that's where a lot of the New South Wales cases will go when we're talking about it. Now, the Air Pacific ticket, it was trying to say like it's non-refundable, right? But they didn't make it clear that this ticket was non-refundable. On the ticket itself, it just said non-end, non-ref. I mean, what does that mean? Non-end, non-ref, non. Like it looks like a puzzle. Like you're supposed to jumble the letters around and then you find something. It's like, so it didn't really make sense. Yeah. So even though they had other documentation that said, okay, the ticket is non-refundable. This is what it means when it says non-end, non-ref. It really wasn't found to be fair. It was found to be unfair because it was unclear on the ticket just what non-end, non-ref meant. Now, there was another case, Malum and Grays Online and Rumbles. So Grays Online and Rumbles are separate businesses. One's a removals business, one is like an online auction business. And this is another CTTT case where the terms were found to be unfair. They were not transparent. The main reason was that some of the terms were inconsistent with one another. One term said, like, basically, you cannot return the goods. And the other said, you cannot return the goods if you had a chance to examine them first. Now, those things are inconsistent because you can't say you can never do it, but you can never do it in this certain you can't do it in this certain situation, right? Because those two things are inconsistent. The second one implies that if you didn't have a chance to examine them, then you can return them, right? So that was an unfair contract term. The structure of the agreement was also confusing, and the length of the agreement for something fairly straightforward. The judge said, look, this is a 13-page online agreement for something that's fairly simple, and it shouldn't be so complex. Right? Now, when we talk about these cases, you need to be very careful. A trap that students fall into every single year is they just recount or retell an entire set of facts from a case. Now, why would you do that? It's a big sign for the markers that you really don't know what you're talking about, because just about any student can tell a story that they were told. Right? So I just told you some stories, some case stories, and sometimes students just go, okay, I'm just going to tell stories the whole time, which is why it's baffling when I read things for legal studies students that go through the facts of the case in enormous detail. Okay, yeah, it's really interesting to read, but you're never going to rewrite it. You're never going to write an exam, so what's the point in having it, right? It's just background, so just telling you that background. The notes from the Marking Center have consistently said that just telling a story, like in this case, there was this person and that person, and this person did this, and this person said that, and this person did this. Telling stories like that, that's not the way to get marks. So why do teachers like me tell you the facts? The first reason is that when you apply it to a real case, then suddenly those weird, letters of the law, the words in the law, suddenly they make sense. Right? Suddenly a phrase like unfair terms, now you've got some examples, they make more sense for you. It also helps you remember the case names, right? Because you actually know what happened to them. So if you know, like if you are from Fiji and you know Air Pacific, you can just talk about the Air Pacific case, right? And just, highlight it, underline it, whatever you want to do to make sure that the markers know that you're using those cases. And you can use these cases to answer the question. It is very important that you answer the question that is asked. So what I've been doing so far is I've been giving you information. How do you use these cases? How do you use these things in an exam? And the best way to do it is to try and keep relating it back to the question, back to the question, back to the question, so that the marker understands, okay, I know why this student is telling me this story because it relates to the question. So for example, one of the past questions, discuss the extent to which consumer law achieves its objectives. Right? So an answer for that, and I'm not going to give you the whole answer, but part of the answer for that would start with saying what the objectives are. So one section of your essay might say one of the objectives of consumer law, as identified by the protections provided by the SEL, is to protect consumers from unfair contract terms. Like that is the objective, the goal, right? And then you would explain what an unfair contract term is. If it causes significant balance, not reasonably necessary, and it causes detriment, and say where that comes from. And that there is also a question of whether the terms of a contract are transparent, right? So then you would move on to using these cases. So success in this area has come at a state level and more recently at federal level. So talk about the state cases. So there you go. You've got Kacharsky and Air Pacific, and you've got Malum and Grays Online and Rumbles. And there's like one sentence or two sentences for each of the cases. So I would recommend not having any more than about two sentences, unless it's you're doing indigenous people and there's like a question about Mabo. You might want to talk more about that. But for the most part, for the most part, you would be talking about these cases in very little detail. You would, you get the marks for the name of the case, and if the markers, recognize it, then that's great. They don't really even need to read the rest of it. But if they don't recognize it, you should just have one sentence that kind of explains why it was unfair, like what the problem with it was. And then you just keep going back to those objectives. So in New South Wales, in the New South Wales CTTT, which is now NCAT, there have been some wins for New South Wales consumers in achieving the objective of protecting them from unfair contract terms. So keep going back to the question again and again and again. Now, the next paragraph here, you can see there's red and there's green because this is where we're discussing. So discuss, bad thing, discuss, good thing, discuss, another good thing. So you need to have points for and against. So you could say the federal over the ACCC has only more recently, so that's not a good thing that it hasn't been doing for a long time, fulfilled the objective of protecting consumers from unfair contract terms. This was initially seen as a failure to act, as there were no prosecutions in the first 2 years of the ACL's operation for this. However, the ACCC had a longer-term strategy in mind, and then it goes through the review that they did and the bite card case, and now they successfully prosecuted that case, the bite card case, and they followed through with further prosecutions from there. So this is, how to use the cases plus the law to answer a question. Avoid long sets of facts. You can see that, I've used the facts. I've really, really quickly given a glimpse of the facts in an exam answer. So I would encourage you to do the same thing. Please don't write really long stories, because they just shit the markers to tears. They're just going, okay, you don't need to tell me about everyone in the case. That's what lower quality students do, because they can remember a story. Because usually stories get told in class or using the app here, and you remember stories. But everyone remembers stories, and the top students in the state, they could tell you a story too, but they're too busy evaluating the effectiveness of the law and balancing both sides and all that. So we want to make sure that you are doing the best impression of a good student that you possibly can. All right, let's move on to contracts with minors. So minors, under 18. Now in Australia, generally, common law applies, and you can't have a contract with someone under 18. It's been like that way for a long time. There are some exceptions, like food, clothing, accommodation. So if you have a contract for, say you're buying something and you're entering into a contract, I guess. If you're going into a rental property or something like that, then yeah, okay, well, an exception can be made because that is benefiting you and that is a necessity. That is a necessity. But in New South Wales, we're not like that because we have a very specific statute law. We have the Minors Property and Contracts Act of 1970. And that allows like 16, 17-year-olds to make a binding contract as long as it is for your benefit. It doesn't need to be perfect. It doesn't need to be completely fair. But as long as the contract is for the young person's benefit, so it's a rental contract or something like that. As long as it's for that person's benefit, that they can't get anywhere to live otherwise, then yes, it is a real contract. Yes, it is binding, right? And the person can be held responsible for that. And that only makes sense, right? Because young people, if you are at a stage where you are under 18 and you're renting a property, then you need you need that property, you need that place to live. So saying, well, you can't enter into a contract. So if like a 17-year-old's been kicked out of home or something, he can't really get his parents to sign a contract for him. Yeah. So you can see what the problem might be there. So that's contracts with minors. The scary part of this contract stuff is the amount of cases that have to do with duress or coercion and this idea of undue influence. Right? Now, for a very long time, we've had these common law. See, I'm pointing them out. Common law protections. Actually, it's it's equity. If you want to be really, really precise, equity. If you remember the Year 11 course, there used to be common law, which is like using precedent. Then equity is like they could kind of make up their own decisions. They just have to use these rules of equity, like he who comes to equity must come with clean hands, and like Confucius shit like that, right? So that when we say common law these days, we kind of mean, we kind of include equity, and we say, inequity, but it's really just, it's still at court, right? So if you want to be really precise, you can say that there are equitable protections or general protections in equity, or at equity, if you want to say it like that. If you want to be really, really precise, but most of the time it's just common law. Don't worry about it; it's fine. Anyway, so people behave badly when they want someone else to sign a contract. So they need to be protected, the person signing the contract. So, for example, if you have a relationship of influence over someone and you use that to get them to sign the contract, it's known as undue influence. So at the top, the box there where it says duress, coercion, and undue influence. So this is what we're looking at right now. So there's a case, Johnson and Buttress. Buttress was a guy who completely relied on Mrs. Johnson while he was alive. He was an old guy. And then he died, as old people do. And he ended up leaving his land to her instead of his kids. So like a gold digger situation or something. But the will was set aside because Ms. Buttress might have had undue influence over his decision to leave the land to her. What were they doing behind closed doors that she was trying to get him? He relied on her. So she said, really, you should be taking care of me after you die. Then, that's using that relationship. And people try to get, the kids try to get parents to do things, the parents try to get kids to do things, and they're using an undue level of influence to get the contract signed, to get what they want. It's exploiting that relationship. Now, the left-hand side, the duress and coercion part, we remember this from crime, and it kind of has the same meaning, right? So you are kind of forcing someone to do it. You are threatening to do something to hurt them or to cause them some sort of detriment in order to get what you want, in order to get them to sign the contract. So the leading case here is Hawker Pacific and Helicopter Charter, where Hawker Pacific was like paid to fix this guy's helicopter, this company's helicopter, and they basically said, look, there are all these problems that you need to pay us to fix, or you're not getting your helicopter back. And the Helicopter Charter, the guy from Helicopter Charter, was going, I need that this afternoon. Like, I've got these very, incredibly important clients. I really don't agree that it needs, this paint or whatever. Yeah. And Hawker Pacific said, well, we're going to keep it then until you end up paying. So that's coercion. They're saying, well, unless you give us what we want now, then we are going to, cause you some sort of detriment. Like, we are going to keep the helicopter. And it was seen as economic duress, and the contract was also set aside. So you'll be surprised that, when you do say, a crime, or you do family or whatever, there's a lot of cases that are losing cases. But you'd be surprised how often the good guy wins in consumer law. It's really quite a positive experience. Now, it doesn't mean that everything's perfect, but in a lot of these cases that you're going to look at for the rest of the topic, it's like that. The consumer ends up getting what they want, or society ends up getting what they want, rather than the business just doing whatever they want. Now, that's the common law stuff. So you had case names. This is the statutory protection. So under the current statute law, coercion is against Section 50. And if you go right down to Section 168, it tells you what the maximum penalty is. And it's $1.1 million for a company. Most of the time in the ACL, if you want to just guess how much the maximum penalty is, it's always going to be like 1.1 million or 1.7 million, right? There are some smaller ones like 60,000, things like that. But if you're trying to explain how good the ACL is, you can say, well, their penalty is up to $1.7 million in there. And then that way, you can look like you really know what's in there without ever looking at it. And undue influence, so it's not just coercion or duress. Undue influence is covered by that unconscionable conduct. So we're going to look more in detail at unconscionable conduct. So arsehole conduct. Unconscionable conduct bans undue influence, because that is unconscionable. That is really morally wrong, to use your relationship with someone in order to get them to sign a contract, to make some sort of legal contract. So let's have a look at the unconscionable aspect of things. So unconscionable, this is something, it should have its own subheading. Now, if the syllabus gets rewritten and consumers are still in the syllabus, say it gets rewritten in 2 years' time, it will have its own dot point. And if it doesn't, I will be completely baffled as to why it doesn't have its own dot point. So the unconscionable conduct is a big part of the ACL. Now, it could have just as easily gone under the marketing part, but you can talk about unconscionable conduct under this heading, under unjust contracts, because the behavior is directly related to the agreement that ends up getting signed, right? So yeah, so it's not your fault. Syllabus was just written at a very unfortunate point in time, the consumer section, because the law changed quite soon after. So let's look at the meaning of unconscionable. Unconscionable, and it's an adjective. It's behavior that is more than simply unfair or harsh. It has to have some sort of element of bad conscience. So there are contracts all the time that are kind of unfair, that are not very nice, that are harsh, that are uncaring, unkind. But for it to be unconscionable, it needs to have this special element of like a bad conscience. So it usually will involve a vulnerable person, taking advantage of a vulnerable person, like an old person, a disabled person, an indigenous person, someone who speaks poor English. These are the types of cases that end up being seen as unconscionable conduct. It needs to be, beyond the normal levels of hard business bargaining. So yes, in business, when you go, like say you want to go and buy a car, yes, there can be some hard bargaining back and forth. But until they actually take advantage of the fact that you're a pensioner and you don't know what you're talking about, and they take advantage of you and lie to you, then it becomes unconscionable because they're doing the wrong thing by a very vulnerable person. And it needs to be very clearly unfair and unreasonable. And the cases that we're going to look at are quite clearly unfair and unreasonable. So really, any action that you would look at and think, what a prick, or what a bastard, how could they do that? That's wrong. When you think wrong, you can just write the word unconscionable. And I challenge you to put that into your everyday vocabulary. It's just like, oh, so-and-so did this to so-and-so. That's unconscionable. And then, watch your friends leave you. All right, so we're going to look at unconscionable conduct under common law, equity technically, and then we look at how it went under the previous statute law and how it goes under the current statute law. So under common law, the case that all the markers are going to know is Blomley and Ryan. Blomley sold his farm at this ridiculously low price. The reason he did it, he was this old, uneducated, his brain was just wrecked, just smashed from being an alcoholic for years and years. He was convinced to sign the contract, while, he was in, that state, while he was this old, uneducated, alcoholic brain. So by taking advantage of that, the High Court considered it to be unconscionable, and they cancelled the sale of the land. They cancelled the sale of the contract. The other case that all the markers are going to know is the Commercial Bank of Australia and Amadio. Now be very careful, because the C blah 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 Bank of Australia, some people write Commonwealth Bank of Australia, and it's not. We're talking about the Commercial Bank of Australia, so not the same thing. If you really worry that you might end up writing Commonwealth, you can just write CBA. Now, the Commonwealth Bank, okay, yeah, they might call themselves the CBA as well, but you can just pretend like, oh, really, I don't have time to write Commercial Bank of Australia, but I know that it's Commercial Bank, not Commonwealth Bank. Anyway, so this guy took advantage of his elderly parents. He told them, okay, I want you to sign this mortgage contract, and the bank knew that there was something wrong here, right? They were at least aware that there was some sort of special disadvantage, right? Now the parents, didn't speak much English, and the son was the one who had to explain it, and the son was the one who wanted the contract signed the most, right? So you can't trust the person who gains the most from this to be the one explaining their obligations under the contract, because obviously he's going to do what he did, which is lie. and the bank knew that there was some sort of special disadvantage, right? That they had to rely on what their son said, and the son was making a lot of money out of it, so it really wasn't fair. So the contract was rescinded, it was taken away, it was removed by the court in that case. Now, if you fast forward a little bit to the previous statute law that we had, which was called the Trade Practices Act, and some teachers still talk about it now. It's just we're doing this because this law and the current law, they are related. They do have bits and pieces in common. So it's okay to look at cases under the previous statute law, as long as you say it was under the previous statute law. It's fine. So anyway, Ramon Lal Kesha. So Kesha, no, Ramon was going around like really, really remote townships, like like little Aboriginal communities in the Northern Territory, in Western Australia, and he was selling these educational materials, which like he would take around, and he'd say, "Well, this is what you're buying," um, and he never provided them, right? So that's one problem. But the huge problem with the contract was that his customers, like they were in a very vulnerable position, and he was getting them to sign a direct debit form, which meant that money would be taken out of their account automatically on the same day, every month, or whatever. He was getting them to sign these things, and then he was just collecting the money. Now, ACCC and Craftmatic was another case where the ACCC went, all right, well, this is unconscionable. This is wrong. This is so wrong. And here you don't have Indigenous people. You have old people. And you've got people there, down the bottom there, old people in bed. Yeah, I wonder what they're going to go up to. Well, they can adjust the bed however they want because it's a Craftmatic adjustable bed. Now, what Craftmatic did is they sent salespeople around to old people's homes, like old people's homes, and they'd say, "Oh, we're just going to we're here to check your mattress to see whether it's okay for your spine because some of you have osteoarthritis and blah blah blah," and just talked a lot of bullshit to get into the house, and then they would say, "Right, we're based on our assessment of your bed, and you or I." We wouldn't take that. We wouldn't let someone in to look at our bed. But if you are worried about your health and these people are presenting themselves as we have this, it's a much healthier bed and it's one that you can sit up and drink your tea and all that. Then you might be, and if you're old and lonely, you might like talking to salespeople, right? And some of the beds went up to $15,000. Now, when they would get into the house, they would start trying to sell the beds. And when some of the old people objected to that, they started getting really aggressive. They started, pushing them into a corner, and getting them, to sign these contracts. Now, Craftmatic learned so much in 2009 that they ended up getting busted again in 2013 for basically the same thing. So it's not like they've really learned, and you can use that as some evidence of ineffectiveness of the law, because they just didn't learn, because their original conviction didn't really stop them from doing it again. Now, the current statute law, the ACL, it bans unconscionable conduct in sections 20 and 21. Now, the penalties could be fines, so infringement notices issued straight by the ACCC that the people pay, or the businesses pay. It could also be banning the owners from running a business for a certain amount of time. Like, you have been, found guilty under this of unconscionable conduct. You are not to be the director of a business for the next 3 years, right? Which, you would think would be pretty powerful, but it's not, because you just get, someone else to run the business and you just provide the money and all that. So the ACL bans it, and the ACCC, what they're looking for when they're trying to work out whether it's unconscionable, to see if it's unconscionable, they're looking for the relative bargaining strength of the parties. So one is an illiterate parent of a child, and the child is taking advantage of them. Their relative bargaining powers are going to be very, very different. Whether any conditions are imposed that were not reasonably necessary to protect the legitimate interests of the stronger party. So if again, like we did with the unjust contracts, if it's not reasonably necessary to have such like an awful term in a contract, then chances are that they're going to find that that's unconscionable. Whether the weaker party could understand the documentation used. So a lot of cases of unconscionable conduct, believe it or not, involve people who English is their second language or their third language, and so they struggle to understand this type of stuff. And it's wrong for a place like a bank or whatever to allow these people to enter into these contracts, and they generally don't do it anymore because they know that if it goes to court, shit's going to go down. You're going to be in trouble for it. And things like undue influence, things like pressure, unfair tactics used by the stronger party. So for, if the Craftmatic case, when it came up again in 2013, they said, look, the pressure, the unfair tactics used by Craftmatic were unconscionable, right? So let's look at some of the cases under the current statute law. So Excite Mobile, they again went after Indigenous people. And they said, right, we have these mobile phone services. And this was a real mess because the contracts themselves were unconscionable, but all the behavior surrounding, how they got them to sign the contracts was also unconscionable, right? It was awful. Excite Mobile, what they did is they pretended like when someone hadn't paid their bill, like they were a little bit late, Excite Mobile would send these letters pretending to be a debt collection agency and say, we are a debt collection agency. Excite Mobile has given us your details, and if you don't pay up, we're going to come and take your children's toys. Like literally, this is what it said. That's not an exaggeration. That's what they told people. So obviously that's wrong, but we don't really just go right or wrong, moral, immoral. It was unconscionable because of the vulnerable position of the consumers. Now, the only reason this case even came up was because there's a group called the Indigenous Consumer Action Network. Because Indigenous people are often trying to be taken advantage of, the literacy skills and things like that they're struggling with. The Indigenous Consumer Action Assistance Network, which is an NGO, that you can mention later in the course as well. They took it to the HSC and they said, hey, Excite Mobil's going and they're saying they're going to take kids away. Now there was never a debt collection agency. It was all bullshit anyway. So it's really, really unconscionable. There is that element of bad conscience there that they knew exactly what they were doing was wrong. And the HSC and Titan was similar in that they targeted Indigenous people again. Now, there's another type of person that can be taken advantage of, and this was in the HSC and Lux distributors. Now, Lux, what they did is they sent these sales reps to the homes of elderly people. So, like Craftmatic, they sent them to elderly people's houses, and these people were like, "Look, I'm not selling anything. I'm just here to do a free vacuum cleaner maintenance check. Can I just take a look at your vacuum cleaner quickly?" Now, one of us, we would go, "Get out of here." Yeah, like, I'm in, Mount Druitt area. I'd probably just stab him, right? So, why would these people get let in? Well, the elderly people would say, "Wow, what a nice young man. He's come to check that my vacuum cleaner's working." Yeah. And then they would say, "Oh, well, I've just found a problem with your vacuum cleaner. The blah 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 valve is broken, and so it would cost a lot to fix." Or, hey, you know what? We've got these vacuum cleaners called Lux vacuum cleaners, and some of them like $2,000 worth, and they would pressure the elderly person into buying it once they were already like inside the house. So they would put pressure on these old ladies. So this was awful, and it was against Section 21 of the Act. And one of the problems, they said, the court, the HSC and the court, end up saying, well, here's a problem with this situation. If you have an elderly customer at your shop, it's very different to you being at an elderly customer's house. Because when you are inside their house, they're very fearful, and they're also very feel they need to be very polite. So they'll often agree to things that they don't really want, just because of those two things. Either they're afraid of, what will happen if they say no. Like older people, panic about locking their doors at night and all that sort of stuff. They're in a particularly vulnerable position, not just because of their age, but because of their age and the fact that this person is in their house. Now, the good news here is that it expanded the meaning of unconscionable behavior so that the people didn't have to be at a special disadvantage. It was the tactics that created the disadvantage. So elderly people are not necessarily at a disadvantage. But what the court decided was, well, the salesperson created the disadvantage by turning up at this person's house. Someone who could walk away when they are at the shops, or walk very slowly away if they're old, couldn't walk away when they're in their own house. So the tactic itself created the unconscionable, behavior. The disadvantage was created by the behavior of the salesperson. Now this brings us to a point about door-to-door sales. We could pick another time to talk about this, but we might as well talk about it now because we're talking about the Lux people and we're talking about the Craftmatic people. When it comes to door-to-door sales, they and telemarketers as well, if you just bunch them all in one, they are trying to get people to enter into what they call unsolicited, unasked for consumer agreements, meaning that the seller is going after the buyer. The seller is going after the buyer. When you go to Westfields, you are a buyer going after a seller, going to seek out a seller in order to buy something from them. Those consumer agreements are solicited. You've asked for them. You went in the shop and you asked, I want to buy this. Unsolicited consumer agreements are door-to-door sales, telemarketers, right? And these have a special section in the ACL just for them. So sections 69 all the way to 88 are just for these types of agreements, these unsolicited consumer agreements. Why? Because these are often the very, very worst types of contracts that they see. So it includes, you have to inform the customer of their rights. You're not allowed to be at their house or ring them up during certain hours. There are longer cooling off periods, like if you go to a shop and buy something versus, you buy something when someone comes to your house. Maybe you are saying yes just because you want them to get out of your house or leave you alone. Some people will do that, yeah, whether consciously or unconsciously. So separately to the ACL, like that deals with the contract side of things, telemarketers have a thing called the telemarketing industry standard, and there's also the do not call register, right? So these are things that have been either created by the industry or passed by Parliament. And the Do Not Call Register Act is enforced by ACMA, which is a federal government body, to make sure that door-to-door salespeople, and to make sure that really anyone trying to get an unsolicited consumer agreement from a person, it has to follow not just the ACL, but there are these additional standards that they need to follow. So there are things like if you tell them to go away, they have to go away, right? Straight away. They don't get a choice. Yeah. So do that. Next time someone knocks on your door, they're trying to sell you something, just say, under the ACL, you have to leave because I'm asking you to leave, and they do have to do it. Now, if we expand on this, there was a special case, the HSC and Australian Power and Gas. Now, Australian Power and Gas, was lying to the customers, misleading and deceptive conduct. We'll cover that later. But they also engaged in unconscionable conduct by trying to get very vulnerable people to sign up to energy contracts, right? So let's say, here's an example, right? There was a woman who really struggled with English. And so there was like an Indian guy came to the house and said, look, we're going to sign this contract now. And what he did was he got the business, got like APG, got them on the line, rang them up with his mobile, and then he just held the phone like in front of her, and they did a contract confirmation call. And you might have heard someone do this before, where you say yes, no, yes, yes, I understand, I agree, blah blah blah. It's a way of doing a verbal contract that later gets turned into a written one, right? So the guy would just point to bits on the paper, and he instructed her, just say yes, just say yes or no, yes, yes, no, no. So he was just pointing at these things on the paper. Now, this is wrong because the person obviously couldn't read what was being pointed at and was just saying yes, because for whatever reason, right? Maybe lonely and just wanted to make the salesperson happy, wanted to please the person, and believe it or not, people do this. So they were found to have breached their obligations, and you've got the energy firm fined 1.1 million for door knock tactics. Now, this has become a real issue, especially in the energy industry. There have been lots of cases that have been brought against them. So, same sort of thing with AGL. AGL got companies to go and do the door knocking for them, so they were in there together, and they broke the unsolicited consumer agreement sections of the ACL. And that AGL case, the AGL case, was the one that held that do not knock signs are a request to leave. Right? So you may have seen a do not knock sticker on someone's door. Now that itself, like the person, in the people in this case, they had a sticker that said, do not knock, but the person knocked anyway and ignored it. And then the person in the house didn't say the words "please leave," right? And the question came up. Wait, didn't they already ask the guy to leave by putting a sticker that said "do not knock"? And the court said yes. A do not knock sign is a request to leave immediately, and do not be there. Do not knock, right? Now, energy companies are kind of known for selling things door to door, and the tricky thing, I know Origin Energy has done it because I've received them. What they do is they went around and signed up all these people to Origin Energy, right? And then once they finished signing up all the people in a suburb to Origin Energy, they realized, hey, wait a second. We got all these customers by, we will pay for their, their transfer fees and all that sort of stuff from their existing electricity company. What if another company comes and steals our customers away? So Origin looked at this case and realized, wait a second, here's an idea. And this is the most brilliant idea that, I've heard for a very long time. They printed shitloads of these do not knock signs, stickers, and they sent them to all their customers. Why? Out of the goodness of their hearts? No, because they sent them to their customers because those were already their customers, and they didn't want anyone coming to take them away from them. So people, a customer, an Origin Energy customer, would open an envelope, and it would say, like, aren't you annoyed about people knocking on your door and trying to sell you electricity? That's how we sold it to you, sucker. Aren't you annoyed by that? Why don't you put this sticker up? And most people just went, oh, okay, all right, I'll put this sticker up. And the other energy companies, so another energy company will come along and they'll go, shit, these bloody Origin people, they've been given these free do not knock stickers because it's free, of course you're going to use it. And now we can't take their customers away from them. It's brilliant. It makes Origin Energy look great because they're giving away free stickers and helpful stickers, right? But what they're doing is they're stopping other electricity companies from stealing their customers away from them, which is brilliant and should be commended because good move, very, very clever. Now, one last thing about these statutory protections. We know that we have the ACL. You should know that by now. And we know that it's included in the Competition and Consumer Act, right? So there's a schedule, Schedule 2, and it says this is the ACL. It's in the Competition and Consumer Act 2010. But we also know that the ACL is copied and pasted into the Fair Trading Act in 1987, New South Wales. But there is another law that you do need to know because teachers who have been teaching consumers for a lot of years will probably be looking for it. That's really the only reason why you would need to know it. And the name of the law is the Contracts Review Act, and this kind of overlaps it. When they passed this, the amendment to the Fair Trading Act, it said, look, the Contracts Review Act is still there, and this overlaps it, but it in no way gets rid of it. Yeah. Now, this Contracts Review Act, for teachers who remember, it was a very useful law for unjust contracts, and it's still in operation. And in fact, it's a little bit better than the ACL in some cases because it covers not just consumer contracts, like consumer buying something for normal consumer use, but it also covers business contracts as well, right? And it does have things about undue influence, and it does have things about unconscionable conduct. So before we had this ACL, before we had these sections, the law in New South Wales that was really relied on was the Contracts Review Act, right? And they have similar outcomes. So back in 2011, it was the people had a choice. We could bring it under like the ACL, or we could bring our case under the Contracts Review Act. And they decided in this case, no, we're going to go with the Contracts Review Act. Despite the fact you had this shiny new law, they still picked the Contracts Review Act. So the case of Fast Fix Loans and Samadzik, which is similar to that Amadio case. It was a son who wanted to get his parents to sign a mortgage contract, and he used his undue influence to get an unjust contract signed. Now, the very last thing, so that's the last thing about statutory protections. Yes, there's another law, but there's also the question of what if it's not for like goods and services? What if the contract isn't for goods and services, right? So we know that in New South Wales, if it's for something else, if it's like a business transaction, then the Contracts Review Act can apply. But what if it's like for credit? Well, we have that. We have the National Consumer Credit Protection Act, the NCCPA, and that has, you guessed it, a schedule in it called the National Credit Code. Now, the National Credit Code is enforced by ASIC. So if there is, an issue with a credit contract specifically, or by financial services, still under the ACL, ASIC is going to be in charge of that. So if it's a question of money, lending money or whatever, then it's going to be enforced by ASIC. Now this time though, luckily there's no duplication. There's just one federal code. There's no, copy and paste, the National Credit Code into a state law, because ASIC is in charge federally because credit can be covered under the Constitution. So there are sections in the NCC, in the National Credit Code, which is a schedule of the National Consumer Credit Protection Act, that cover unconscionable conduct. So if, say, the rate of interest charged for a loan is unconscionable, then it's going to be changed by the court. The court can change it or get rid of it or whatever. There's also, things about unjust transactions as well. Like undue influence, trying to get someone to sign a credit contract, like a credit card contract or something like that. These things are also covered. So we really have all our bases covered here. And the credit stuff, we go into a lot more detail right at the end of the topic in the contemporary issues part. So we'll look at that in more detail. If you're thinking, wait, that wasn't much about credit. Yeah, we do a lot about credit. We do a whole section about credit. So don't worry about that too much. So those are the unjust contracts. And the next part we need to look at like marketing and things like that.